All right, good afternoon, everybody. We'll go ahead and get started. My name is Jared Pone, and I have the privilege of serving as today's moderator for today's session on the hidden cost of longer-term installment loans. I serve as a state policy counsel here at CRL in our Durham, North Carolina office. And joining me today will be my dynamic colleagues, Charlotte Rios and Monica Burks, whom you will have the pleasure to meet shortly. But before we get started, if you have any questions throughout the presentation today, we do plan to end with a Q&A at the end. So feel free to put your questions in the Q&A box located at the bottom of your screen. Next slide, please. All right, so now you know me. I'm Jared Pone, like I said a few moments ago, and this is my contact information. If you ever have any questions, comments, or concerns, or you need to reach me, please feel free to do so. Next slide. So the Center for Responsible Lending, we are a nonpartisan, nonprofit research and policy advocacy org working to promote financial fairness and economic opportunity for all, to end predatory lending and to close the racial wealth gap. CRL is an affiliate of Self-Help, one of the nation's largest nonprofit community development financial institutions. And our work leverages the strength of partnerships with national, local, consumer, and civil rights organizations. Next slide. So what is a webinar without a few housekeeping notes, of course? So yes, we will be recording this webinar, as you guys are aware, and we will also provide report outs. At the end, there will be a Q&A session, as I mentioned before, so please be sure to use the Q&A box at the bottom with your questions, and we'll make sure to answer them at the end. We'll also save time additionally for a discussion of where these issues are coming up in your state and how we may be helpful to assist you going forward. Next slide. So we have a twofold purpose for today's webinar. The first purpose is to provide you as advocates with a look at what is happening in the states and the practices that make higher cost, larger consumer installment loans concerning. And the second purpose is to empower you as advocates with the knowledge of how to combat these higher cost, larger consumer installment loans in your state whenever they come knocking at your door. Next slide. And of course, as any good advocate, you're wondering, well, how are we going to get there? I'm glad you asked. Our agenda or our roadmap for today includes defining what exactly are higher cost, larger installment loans, and taking a look at the trends in the larger consumer installment lending area. We're going to take a deep dive on our latest research in Colorado, and also take a look at the multi-state attorney general's lawsuit against Mariner Finance. And of course, we're going to end with a Q&A session. Next slide. But to understand how these high-cost, longer consumer installment loans work, we must acknowledge the current financial state of consumers. Over the last 4 decades, the financial balance sheets of Americans have suffered. Hourly wages have stagnated, and the cost of housing, higher education, childcare, and healthcare have soared. Recent research from the Financial Health Network found that the proportion of people considered financially healthy declined in 2022 for the first time in 5 years. In 2022, less than 1/3 of people were financially healthy, which is down from 34% in 2021. The percentage is even more alarming for Black families, with only 15% being considered financially healthy. These declines are related to the fact that people are not earning sufficient income to cover basic living expenses. However, this financial unease has created opportunities for credit products, including those from high-cost, larger consumer installment lenders, to be introduced as potential solutions for shortfalls in income and savings. And that is why we're going to examine them today. Next slide. So there are many problems and abuses associated with both types of high-cost installment loans. Our presentation today will focus on the larger loans, but for completeness, we want to take a minute and give you a sense of where these smaller loans look like, as payday lenders are increasingly seeking to expand them into these types as well. So the smaller loans are typically associated with payday. They typically are from $1,000 or less, but some can push upwards of $2,000. They often have triple-digit interest rates. And the solution to those are typically to limit 36% APR rate caps, and that's all in APR rate caps. Now, the loans we're talking about today are larger loans. They're typically $8,000, can be $8,000. Some can be lower than that, and they go upwards of $20,000. However, they can be higher. In some cases, for instance, in the great state of Florida, their installment lending goes up to $25,000. Another characteristic of installment lending, higher cost installment lending, excuse me, is that they're often secured by household goods, and they're often packed with junk insurance that we'll talk about a little later in the presentation. And the way we combat these are to cap rates much lower than 36% APR, including those junk fees that we talked about. Next slide. So we've seen a shift in the payday loan industry away from traditional short-term payday loans into longer, bigger, predatory installment loans. This shift allows them protection from payday loan caps, and it works out well for them financially because it's a bigger and deeper debt trap. This shift happened for a number of reasons. First and foremost, states begin to crack down on the harms of these type of loans by enacting a 36% all-in rate cap on small dollar loans. These rate caps are the primary vehicle by which states protect consumers from predatory lending. However, in some instances, the industry begins to reinvent itself and pivots to another product, as we'll discuss a little later in the presentation. But as shown in the chart above, the APR for the bigger, longer installment loan is lower than what it is for the traditional 2-week payday loan. But that does not mean that it's a better product. If you take a look, the high cost installment consumer loan offers a longer period of indebtedness. That is 24 months compared to 5 months, where borrowers could face more issues with additional debt burdens not being able to be fulfilled. Most importantly, the total cost of repayment is significantly higher. $750 total repayment of the $300 payday loan compared to $6,336 total repayment for the $2,000 installment loan. Remember, this is a bigger, deeper debt trap that is harder for consumers to get out of. Next slide. Taking a look at the larger loans in contrast. The larger size and longer term high cost consumer installment loans can generate high costs for lenders and a larger deep debt burdens and finance charges for borrowers at APRs even in the 20s. For these loans, once you get in APRs in the 20s, the loans are extremely expensive. On top of this, as you'll hear in a few moments, these loans have other features that unreasonably increase debt burdens and costs. Next slide. Some of the largest lenders in this segment of the market have lobbied state legislators to weaken state consumer financial protection laws, governing maximum allowable interest rates, and permit lenders to make higher cost loans than the law currently allows. Industry proposed many changes in the states that include drastically increasing the interest rate on consumer finance loans to 36%, and that's plus additional fees for most loans, increasing the interest rate on loans with a higher principal balance substantially, and increasing the cost lenders are permitted to charge borrowers. These lenders claim to benefit consumers by offering affordable, responsible credit, yet little is known about the lending practices occurring in this market. Next slide. In the great state of Florida, the Financial Services Association, the FFSA, went so far as to misrepresent the 36% all-in stance on small dollar loans that consumer advocates such as CRL support. The industry claimed in print and verbally that CRL, the NCLC, and the Pew Charitable Trust support 36% on high-cost installment lending, and that is simply not true. In fact, CRL and NCLC submitted cease and desist letters to the industry and shared them with legislators to ensure that our stance is properly stated in opposition to their proposed legislation. Remember, we talked about this in previous slides. So the larger installment loans, most consumer advocates support below 36% because it's a larger loan. For the smaller loans, like the payday loans, most consumer advocates support 36% all in. So it's two different type of products. The industry is purporting to say that we support 36% on the larger product, and that simply is not true. So currently in the state of Florida, they have a tiered interest rate for their installment lending. They employ 30% APR for loans up to $3,000, 24% APR for loans between $3,000 and $4,000, and 18% APR for loans above $4,000. And as a matter of fact, their bill was actually filed a few hours ago at noon today. Senate Bill 580 is the title of it. And if you take a look-see on the analysis we did here on the slide, under the current law, a loan for $25,000 is at 18% APR, well, 20% APR, because got to add in the $25 background fee, of course, some other additional fees, which has a total repayment cost of $40,175.33. Under the new proposal, changing it to a 36% APR, it would have a total cost of $54,251.13, raising the repayment cost by $14,000. $14,000, ladies and gentlemen. That's a larger, deeper debt trap. Next slide. Although there is extensive research demonstrating how payday loans impact on consumers, little research exists regarding the impact of high-cost installment loans on consumers' financial health. To this end, CRL conducted a survey and 2 focus groups with high-cost installment loan borrowers to better understand the effects of the loans on personal finances. The data birthed our September 2022 report titled Unsafe Harbor: The Persistent Harms of High-Cost Installment Loans, which we'll share with you in the chat in a few moments. Key findings derived from this primary data included unfavorable high-cost installment loan terms led to loans being refinanced at least once. The burden of repaying high-cost loans often caused borrowers to miss payments on other obligations, resulting in additional debt or a larger financial deficit. And borrowers felt that they had no other option for meeting short-term financial needs. But to further elaborate on our most recent research on high-cost consumer installment loans in the great state of Colorado, allow me to introduce you to my friend and our Deputy Director of Research at CRL, Ms. Charla Rios.
Thanks, Jared. We can go to the next slide, please. Hi, everyone. Good to hear from folks and good to see so many folks on the webinar. My name is Charla Rios. I'm the Deputy Director of Research here at the Center for Responsible Lending, and looking forward to speaking with you all about our most recent research in Colorado looking at supervised installment loans. Next slide. So just to give you a background of how the Colorado market looks, these are a few different offerings of the products offered in Colorado. You can see your deferred deposit loans, which are the maximum dollar amount is around $500, your alternative charge loans, as well as the supervised loans that we'll discuss today. That will be our focus. You'll note that the interest rate is tiered on those supervised loans up to 36% for $1,000, between $1,000 and $3,000, it's around 21%, and then 15% for anything above $3,000. So again, our focus will be those supervised loans in this research and in this portion of the discussion. Next slide. So thinking back over a period of time in Colorado, there have been attempts to raise the rates on supervised installment loans. Starting back in 2015, there was HB 15-1390, which attempted to expand the size of the balances on which the higher rates could be charged. That was vetoed by Governor Hickenlooper at the time. But then 2 years later, there was another attempted increase to the APR to adjust for inflation. And then most recently in 2021, there was an attempt to increase the rates on all supervised installment loans to a flat 36% on all loan sizes. And again, if you remember from that previous slide, the current law in Colorado allows for a tiered structure on supervised installment loans. Next slide. So thinking about our research in Colorado, we most recently published a report called Upsold and Weighted Down, focusing on a subset of supervised installment lending in Colorado. We reviewed 67 loan documents from 2 multi-state companies, Lendmark and OneMain. The loan sizes ranged in that sample from $2,000 to over $15,000. The term lengths were anywhere from 18 to 60 months. And then nearly half of the loans were secured by collateral. There were a few different limitations, though we don't feel that those affect the findings of this paper. One is the geography. So we looked at cases in Denver County, Colorado, and we also made note that the nature of the cases, these cases were in default. So that is another potential limitation, though again, we don't feel that that compromises the findings of this report. If you'll click ahead, then you'll see some of the demographics of our report sample. Again, we looked at Lendmark and OneMain. You can see with the OneMain cases, there were quite a few that were over 48 months in length, and then in comparison, the Lendmark cases as well. Next slide. So this is an example of a loan document from one of the 2 lenders in our sample. This is also figure 2. If you look at the report, that we'll make sure to share in the chats shortly. I'm going to cover some of the features that we've highlighted for those that are less familiar with these documents. So you can see that the loan, or the amount financed, was $4,445.91. The amount that was originally borrowed was $4,000, but this loan includes insurance products that I will cover in a second. There's also a $2,000 finance charge for a total repayment of over $6,000, $6,533.25 in total. The payment schedule is 38 months, with the first payment being over $200. $204.77, and the subsequent 37 monthly payments being $171.04. Now, this assumes there are no late fees, which would essentially drive up the annual percentage rate if there were, and those were included. Finally, this is a secured loan secured by the borrower's motor vehicle, as well as there are 3 separate insurance policies that you can see at the very bottom blue box on the screen. These policies include the disability, life, and unemployment insurance. And these insurance are paid by the borrower, but ultimately are not of benefit to the borrower, but benefit the lender to account for their potential losses. And again, we looked at 67 of these types of documents across our sample. This is just one example. Next slide. So in this figure, figure 7, you can look at some information around some of the dozen or so loans that we saw. And this set of loans particularly points to some of the add-on products that made up more than 1/10 of the loan funds. This chart shows how many insurance policies borrowers purchased as part of their loan transaction and whether they also finance an auto club membership. You can see how the cost of these add-on products contributes to the overall loan amount. I'd like to call particular attention to the very bottom case, Preston and Emma. And I should note that we have used pseudonyms to protect the borrower's identities in our sample, hence why you see the names in quotation marks. But Preston and Emma, about 1/3 of their loan amount went to insurance products. So we'll take a look at the next slide where we'll look deeper at the terms of their loan. And you can see here, even though it's a little blurry, this is the Truth in Lending Act disclosure, or the TILA form that's required by federal law so borrowers can try to compare the cost of credit. You can see that the APR is quoted at 20.98%, so around 21% APR for a loan that is secured by a motorcycle. So Preston and Emma in this transaction received no cash as part of it. The money from the loan went to pay for life insurance, accident and health insurance, involuntary unemployment insurance, and the rest of the loan was refinanced using an existing loan that they already owed to their lender. And then if you click ahead, we kind of distill down this loan document into figure 9 in the report, and you can see that the APR disclosed on that TILA statement, or the Truth in Lending Act statement, doesn't include the add-on charges, keeping the APR low and perhaps helping people to think that the cost of credit is lower than it actually is. So if we included those into the annual percentage rate, or the APR, we found that the APR was around 47%. And you can see some of those, again, the terms, the add-ons, the finance charges to see the total cost. Next slide. So we hope that you all will take a look at the report. It has a lot of good information in it. Again, more loan documents, so you can see some of the breakdowns of the things that we have shown. But some of the recommendations or reflections that we have based on this research is, one, we believe that regulators should examine their license to ensure lenders are not deceptively pushing borrowers deeper into debt through loan-related transactions that profit the lender at high cost with little benefit to the borrower. And regulators should also ensure that lenders don't use loan renewals, which I didn't touch on here, but is another feature that we saw across the data set, to further facilitate sales of insurance and other add-on products, or inappropriately extend the period of indebtedness that borrowers who would have otherwise repaid their loans within that term length originally. We believe that AGs should also hold lenders accountable, and likewise the CFPB, or Consumer Financial Protection Bureau, should ensure that consumer finance lenders are not engaging in unfair, deceptive, or abusive, otherwise known as UDAP, practices that harm consumers. And then finally, the weakening of interest rate laws. Again, Colorado and other states as well have either tiered structures or lower rates. And these kinds of proposals, as we have mentioned, there has been attempts by industry to increase the rates that will ultimately result in higher costs to consumers. So state law should be strengthened to include the cost of add-on products when determining finance charge limits, and lawmakers should not weaken state laws through these attempts that we've seen in many states. So with that, I will kick it over to my colleague, Monica Burns, who is a policy counsel here at the Center for Responsible Lending, and look forward to your questions. Thank you.
Thank you, Charla and Jared, for all of that really helpful information. Good afternoon, everyone. My name is Monica Burks. I am policy counsel here at Center for Responsible Lending. And today I have the privilege of talking to you about some very important and exciting litigation that's happening starting in the state of Pennsylvania. So let's get into it. And I can't wait to tell you the progress that has been made. This litigation was initiated by the Pennsylvania Attorney General, who is now the governor of the state. And this litigation was joined by several other states. If you could go to the next slide, please. So we had Pennsylvania joined by Washington, New Jersey, Oregon, Utah, and Washington, D.C. And they sued a company that goes by the name of Mariner. It's a company that is held by a private equity firm. And I think it'll be helpful to walk through an illustration of what the consumer experience has been with this company. And then I'll go through the different methods that the company is using to push its products. And finally, I'll talk to you about the different claims that this case brings to hold them accountable. So Mariner is a loan company. It advertises itself as such. And usually what happens is a person will come into one of the brick and mortar branches after receiving various types of marketing media. One way that Mariner markets itself is by sending consumers unsolicited live checks. So they will send out a dollar amount in a check that the consumer can cash, and by doing so, enter into a loan relationship with Mariner. After that, the person will go into a branch to, most of the time, refinance the money because they don't have the funds to totally pay it off. They will be encountered by a loan representative who is personable, friendly, and really a salesperson. They will discuss with the loan rep the terms of the loan, like the amount, the length, and the number of payments that are estimated. After a really cursory description of the loan product, the client will be directed to use a digital signature pad to consummate the transaction. And so you all may be familiar with these pads. They're I think most recently I saw them at a car dealership. Sometimes they're used for mortgage closings, but really it's just that little box that you sign in, and it's disembodied from the loan documents. And in this case, the customers most of the time would have to look at the loan documents on a wall-mounted screen that was some distance away. And the loan rep is controlling the pace at which they move through these documents. So the client really doesn't have time to really read what they are signing, and they are relying on the oral representations of the loan officer as they're entering into this transaction. So it's about a 44-page document. There are 12 different areas where the customer has to sign to close out that transaction. Now, while the loan officer is walking the customer through the transaction, they will often glaze over a very important point, which is the fact that there are 6 different insurance products that Mariner offers, and offer is generous. They push on their clients via different methods. Most of the time, the state AG found that these loan reps would say either nothing about these 6 different products and the premiums that would be added to the loan on top of the interest that would accrue on those premiums, or they would explicitly or implicitly imply that the products are free to the customer. Other reps would lie and say that the products were mandatory in order to consummate the loan transaction. So we have, in that process, after the loan rep has established a rapport, you have the trust of the client. They are using that information to mislead the consumer and severely inflate the price of the loan. Now, after the loan is completed and the check is issued to the customer, they leave that branch with only a 3-page document, which represents the loan note, which is just the very basic information, the total amount, the number of payments, and maybe even the APR. Most customers do not find out about the premiums for add-on insurance products until months later, either by logging into the Mariner online portal and discovering that their balance is much higher. In some instances, it wasn't until the customer pulled their credit report and discovered that their loan balance had grown much larger than they were understood it would be. After that, they would reach out to the loan representative or go back to the branch seeking an explanation. Many times, the state AG found that loan representatives would tell them that they could not cancel these add-on products, that it had to stay on the loan. Other times, they were told that the add-on products would be removed, but the removal never occurred. As the loan balance grows due to the already very high interest, as Charla and Jared discussed, the customer is often forced to refinance the loan. And in that process, Mariner has a policy that every refinance has to come with additional cash out. So the customer has to increase the loan balance by at least $500 in order to refinance it. So you can see how that debt trap is very intentionally designed in this situation. So what we learned in this complaint is that Mariner is targeting subprime borrowers, people that they know have been excluded from the main banking institutions and don't have a lot of sources for additional funds, folks with low FICO scores. The complaint reprinted an email that was shared by the COO of Mariner back on April 9th, 2021. And in it, he said, hopefully the stimulus checks and their negative impact on consumer demand are behind us. So they are very intentional. They know who they are preying on. They're preying on people who are often in economic and financial straits and will have no choice most times but to default to their products. Now, if you go to Mariner's website, they market themselves as lenders. Customers come to Mariner for loans, not insurance products. However, there is no mention of any of the 6 products that they offer that they put into these loan products. There's no mention of it on the website, on the live checks, anywhere. And 80% of the loans that Mariner makes have these insurance products added on. There's an average of $500 per loan nationwide in insurance products added to each customer's loan. And not only, I may have mentioned, but not only is it the amount of the premium that's added, but that amount begins to accrue interest as well. The AG found that in a random sample of 100 loans made in Pennsylvania, 75 of them had added products for an average of $1,085 in premiums and associated interest. And that works out to $32 for every $100 that the customer borrows. So just astronomical amounts of fees and interest that the customers were unwittingly coaxed into. In some cases, they found much higher rates. For instance, one woman was charged for a $1,000 loan, $1,700 in add-ons, resulting in $95 in add-on fees for every $100 she borrowed. And there are many examples in this 144-page complaint that illustrate how absolutely harmful these products are. We also discovered, if you can go to the next slide, please. In 2019, Mariner charged consumers $121 million in premiums, excluding the interest that they earned from it. The complaint included transcripts of emails from leadership at every level of the company, pressing representatives to increase the number of add-ons at each cell. They published the sales rates from the district, regional, branch, and individual reps. Commission is one way that they incentivize individuals to push these products at any and all means, and discipline is the other method. Representatives and branch directors have been put on performance improvement plans for failing to meet sales goals. Now, the main directive that the AG reprinted in a complaint that goes throughout the company is that everyone is to offer every product to every customer every time. And every time includes every time that a customer has to refinance the loan. So even if the customer was able to overcome these misleading rebuttals to having these products removed, every time they're forced to refinance, they have to run the risk of having these products added back on again. There is a special team that Mariner has that they deploy to specific branches. And the main goal of that team is to increase the add-on sales for these insurance products. And to great effect, most times when they leave the branches, they are increasing the amount of add-on sales by about 45%. All the way up to the CEO, we see that these insurance products are really the main goal of Mariner. The CEO met with several different insurance agencies, and the complaint reprinted a quote from one of these pitch meetings that the CEO had. And in that, the insurance company promised that Mariner would greatly increase the commissions they earn by selling these products if they went with that company. In some cases, Mariner receives 75% of the premiums charged to consumers as commission. So not only were they forcing these products on the customer without their full knowledge and consent, but they're also benefiting greatly from that deceit. So because of this systematic deception and misleading of customers, the state AG filed 15 counts of relief against Mariner. Most of the laws at Mariner are in violation of implicate the different states' unfair, deceptive acts and practices laws. So, and then also the Federal Truth in Lending Act is implicated. Those laws require certain disclosures when you are making representations regarding loan products and insurance products. You have to be upfront about the total cost. So for instance, here where Mariner insisted that the add-on charges were required to make the loan, that then became a cost of the financing. And under the Truth in Lending Act, that information needed to be fully on display. How much did it cost to get that money? What is the APR, including the premiums and the interest associated with those premiums? Mariner provided none of that information. They also brought charges against them because of the deceptive way in which they sold the products, withholding printed information from customers, even when they asked for information about their loan, about the 44-page document that they signed. Mariner was reticent to provide that information that the customer was legally entitled to. So at this point, the case has been a little bit dormant because the AG transitioned to a governor's position. However, there is a new deputy AG who is picking this case back up, and hopefully it will be moving through the court system so that these folks can be held accountable. So I'll pass it back to Jared so he can talk to us about what our next steps and what our recommendations are from here. Thank you, everyone.
Thank you so very much, Monica, for that, and Charla for your insight as well. So we have a few recommendations. If you want to go to the next slide, please. We have a few recommendations that we just want to highlight as kind of a closing segment on our time together today. In sum, we want you to keep in touch with us here at CRL, updates, technical advice, or strategy support. We are here to be your assistant, to assist you in every way as it relates to these efforts. Keep an eye out for harmful changes on high cost, larger installment lending in your state. Just because it hasn't hit your state yet does not mean that it may not be coming, or that the industry does not have their eye on your particular state. We're seeing them in Florida and Colorado and Indiana, all over the nation, from the East Coast to the West Coast. Speak out if you hear the industry misrepresenting consumer advocates' 36% stance. This is a big one. Let us know if you're hearing them saying that CRL in particular or other national consumer advocates support raising the rates on high cost consumer installment loans. Remember that you learned today that that is simply not true. That is not our stance, and that we are doing everything we can to combat the industry's attempts to mispurport our stance in public. That's both in writing and in verbal as well. And also share what you learned today with your coalitions. We know that you guys represent many great coalitions from across this nation. The best asset we have in our toolbox of sorts of advocacy work is you. You're literally boots on the ground, the hands and feet of the work that we strive to accomplish one day. We'll not be able to do it without you. So share what you learned today with your various coalitions. And with that being said, we can go to our next slide and we can begin some well, my favorite part of the presentation, some Q&As a little bit, and we can go from there. So please feel free, if you have any further questions, feel free to drop them in the chat. I know we have at least one or two in there now that we can jump in on and see if others come about, but feel free. There's no such thing as a dumb question. The only dumb question is one that doesn't go asked. So ask away, we're here for you. The first question, I believe, is from Jessica Moody. Hey, Jessica. Our question is, if your state does not allow auto title lending, is OneMain still able to secure these loans with the borrower's vehicle? So the lawyerly answer is simply, it depends on how your state's code is written as it relates to secure contracts of sorts. But in the state of North Carolina, for example, we do not allow title lending, but installment lenders can secure their loans by vehicles still, because it's an installment loan, not a title loan per se. So that's kind of how they do it in North Carolina. But I'll defer to any of the panelists if they want to comment on this question as well.
Sure. Yeah, and thanks for the question, Jessica. So in the case of Colorado, because that falls under their supervised, or a subset of their supervised loans, it's again not a car title loan, but however, they do allow for some kind of a product to be, because it's a secured loan, you'll need something to secure the loan with. I think I believe that usually comes in the form of either the vehicle, or it could be a household personal item. But of course, for many folks, their vehicle may be the most price-wise, the highest dollar possession that they have. So in some, we did see that loans were secured using a vehicle in the state of Colorado. And it sounds like both that was the case in Colorado, but it also happens in North Carolina, it sounds like, even though we don't have title lending here in this state.
Another thing I just want to mention is that, and Charlotte hit on it, in our findings in Colorado, we also found that lenders use household goods. And people may not think that it's a big deal when you have a household good as a secured interest. But it's really is a big deal, because it could be things that you really need, like a refrigerator, a washer and dryer. And sometimes those are things that are even more important than a vehicle, based upon your situation. So that's something to consider as well. Let's see. I have a question I want to toss out there. In Colorado, why did we only look at OneMain and Lendmark? Why do we only look at those two specific lenders?
Sure, it's a good and fair question. In the state of Colorado, these were two of the largest lenders that provided these types of loans. And so when we looked at the case files, those are the two lenders that we saw the most. Although we looked at those two lenders, it doesn't mean necessarily that this practice is just common to these two lenders. In fact, we believe that it's happening with other lenders as well. However, these are the two that were the largest in Colorado. So I would encourage, if anyone else wanted to replicate this in their state, to consider who are the largest lenders within your state that are offering these kinds of products in relation to your state laws, and see what the practices are. In the case of Colorado, though, it was these two that were the highest cited.
Thank you. And for just to toss this out there, for those advocates who are representing states who maybe do not have a cap at the moment on their high cost consumer installment loans, and they want to do so, what should be their first step for their coalition in trying to kind of get a grasp on this particular type of loan, these high cost consumer installment loans? What should that coalition do?
I could start us off, and then if others have points to jump in, but I am a researcher, not a legal expert. So the researcher in me is to know the landscape of your state, right? So if you, many states have a variety of types of consumer installment products, excuse me, in the realm or the arena of their state. If you're looking specifically at installment loans, again, get a good lay of the land, whether it's the regulator has data, or maybe it is connecting with folks and looking at their loan documents. Maybe it is our approach that we took in Colorado. So that is where the researcher in me would say to start, but I can pass it to others who have much more of a legal analysis.
Awesome. I have a legal analysis, but I'll just start where I find myself, and that is to start with your own coalition. Figure out who has the knowledge and the contacts to understand the legalese in your particular state code. And if not, reach out to us here at CRL. We have an open door policy, for lack of better words. Most of you know the state team contact who represents your particular state. Reach out to us, let us know if there's anything we can do. We could definitely do some initial research and intel and try to break things down in a bite-sized manner for you. But definitely utilize those resources here at CRL. And you can also just start to advocate and enhance your coalition itself. Like we said, we want to make sure that we are supporting you guys. We may not be in your particular state every day, every year, for lack of better words, but if there's anything we can do to be a backstop for you, we are definitely here for you. So that would be my little 2 cents to add there. Do we have any other questions?
Jared, I think I see one around why 36% for why are advocates against 36% for high cost installment loans as compared to small dollar loans. Not sure if you or Monica would like to take that.
I'll defer to Monica if she's available. If not, I could definitely do it.
Yeah, sure. I'm happy to chime in. So it's my understanding that 36% rate caps in most states effectively shuts down storefront payday lending. So it prevents a lot of harm that would otherwise exist if we didn't have the cap. However, 36% on a larger dollar amount for a longer term, it really adds up and it keeps the consumer in a debt trap that is very, very hard to escape. Many times when you have loans at that size, the majority of the minimum payments go toward the interest and very little goes towards the principal. And so you really see a constant cycle of that balance continuing to grow despite efforts to pay it off. So 36% is incredibly high for larger dollar loans. And that's why we do not want to represent that we're okay with that being charged for these several $1,000 loans.
Totally agree. Totally agree. And there's an example in our slideshow here that shows that on, I think it's slide 9, particularly that folks can take a look at and get a real life example for themselves, and they'll be able to see the difference between what a rate of 36% will look like for the large installment loans and why we do not support those for the larger high cost installment loans, and why that is a good option for the smaller dollar loans. And that's 36% all in, including the fees and things of that nature. So I think that's a very good thing for us to kind of delineate, is that it's 36% all in, not 36% plus. So I think that answers the question there.
Yeah, and I think one thing I would add, thanks Monica and Jared, is just to re-emphasize with a lot of these installment loans, as you saw in the Colorado research, and you may see in your own states, that some of these are not 36% all in. In that example of Preston and Emma, they had a loan that was calculated to be an APR of around 20%. When you added in all the additional costs and fees and insurance, it drove it up to around 40, 45, 47% APR. So that's the reason why even when you have larger loans, when you have a larger APR, that is really going to drive up the cost of things.
All right. And if there are no further questions, I will just point out once again that Preston and Emma are located on your screen right here, the last column here. So you can really take a look at that for yourself. But if there are no further questions, we thank each and every one of you for your time and your participation today with us on this webinar. We pray that it was exciting for you and that you learned something valuable that you'll be able to take back to your coalitions, and they'll be able to help you in the fight ahead. If you need anything from us here at CRL, feel free to reach out to us. Our information is located throughout this presentation, and we are honored that you chose to spend a little bit of your time with us today. Thank you so much for your time and your participation. Have a wonderful day.